Be ready. Start. The point for consideration is whether the impugned judgment of the High Court dismissing the case after recording that prima facie case was made against the respondents, thereafter framing charges and recording evidence of the parties without adverting to the plea of the parties and evidence on record, by concluding that the second application was under a different circumstance, being contrary to Rule 13 of the High Court of Karnataka, Contempt of Court Proceedings Rules 1981, read with Section 264 occurring in Chapter 21 of the Code of Criminal Procedure 1973, is legally sustainable. Since we have already narrated the facts of the case, there is no need to refer the same once again. Learned Senior Counsel for the appellants submitted that even as early as on 15/10/2015, the Division Bench of the High Court, based on the materials placed, concluded that a prima facie case against the respondent stroke accused have been made out for proceeding further, and directed framing of charge to try them for criminal contempt for abuse of process of law. Another coordinate bench, while passing the impugned order dated 18/6/2008 without reference to any of the materials, simply dismissed the petition filed by the petitioners therein, appellants herein. Perusal of the initial order shows that the division bench considered the contempt petition filed against the accused after obtaining the consent of the learned Advocate General in writing under Section 15(1)(a) of Contempt of Courts Act 1971. Pursuant to service of notice on the respondents, they submitted their objections along with certain documents in support of their defense. It was contended that the action complained of do not constitute abuse of process of the court for taking cognizance in the matter and to proceed further for framing the charge, as rightly pointed out by the division bench in the order that in terms of Rule 8(2)(a) of Contempt of Courts Rule 1981, the matter was heard initially to find out whether there is a prima facie case to frame the charge against the accused persons. The complainant placed strong reliance on the allegations made in the complaint and also the order passed by the trial court in the earlier application filed by the first accused in respect of property against which a decree is sought to be executed by the complainant in the execution proceedings. In the preliminary order, the court had also referred to the observation of the executing court. Ultimately, the executing court has convicted the judgment debtor and others. The matter is still pending before this court. The complainant has also alleged that after the order passed on the application filed by the first accused became final, a decree was sought to be executed to take the possession of the premises. At this juncture, the second accused has filed another application taking another plea, and according to his counsel, the subject matter covered in the application is different from the earlier one, and that the identity covered in the eviction petition and the claim made in the application filed by the first accused before the executing court is entirely different. In other words, it is defense that the order passed on the earlier application filed by the first accused does not come in the way of executing court to 9 independently consider the application of the second accused in order to determine the rights of the parties. In the preliminary order, the division bench rejected the said contention and prima facie found that it is untenable in law in view of the earlier application filed under Order 21, Rule 9 of Civil Procedure Code 1908 by the first accused, and concluded that the earlier application and the present application have to be treated as one and the same. After adverting to the respective stand of the parties, various decisions of this court in the preliminary order dated 9/6/2006, The division bench has concluded that we have carefully perused the record and the documents produced by the complainant and also the accused persons. After careful perusal of the averments made in the complaint and the statement of objections and the orders passed by this court in the eviction proceedings, and also the order passed in the proceedings and the law laid down by the Supreme Court in the cases referred to supra, upon which strong reliance is rightly placed by the complainant, we feel that there is prima facie case against the accused to proceed further, frame charge, and to try them for criminal contempt for abuse of the process of law. Inasmuch as the impugned order does not contain adequate reasons and material as found in the preliminary order by another coordinate bench, it is useful to extract the exact impugned order of the division bench, which says that without reference to merit of the contents taken in the second application, we hold to suffice that the grounds made out in the second application is under different circumstances. The identity of the property is disputed. Factually, we find that the accused cannot be attributed with unlawful intention of abuse of process of the court. In the view of the matter, we do not find any good ground to hold the contempt under section 2E of the Contempt of Courts Act. Accordingly, petition is dismissed and the accused is acquitted. Thank you.